once we get going then. Thank you, Chair.
Wow.
Okay, members, streaming is now live. I'll hand over to you, Chair, to start the meeting. Thank you.
Thank you, Paul. Good afternoon, everyone, and welcome to Darlington Council's Planning Application Committee. My name is Councillor Doris Jones, and I'm the Chair of the Planning Committee. Before we start the meeting, I need to make a few introductions. The councillors, this is really for the benefit of the public. The council's members of the planning application are the members who will make all the decisions on the voting, and they vote on each application. So for clarification, could members please show their hands? All members, please. Thank you. We have some senior planning officers present as well. We have Mr. Dave Coates, who is Head of Planning, Development and Environment. We have Mr. Andrew Harrington, who is our governance and lawyer. Do we have a highways officer with us, Mr. Coates? Not today. Okay. And then we have our Democratic clerk, which is Mr. Paul Dalton. My role as chair is to maintain order at the meeting and ensure that the meetings proceed in accordance with the council's planning protocol. However, if any vote is tied, I will have the casting vote. But do we have any attendance from architects or representatives from the public, Mr. Coates? None, no representatives. So it's purely just members and members of the public who are in. Thank you very much. Somebody trying to speak? Is there a problem?
Not that I'm aware of, Chair. Everything seems to be okay.
Oh, yes, there is.
This is Councillor Tate. This Councillor Tate has actually messaged through, Paul, about only seeing a certain number of people on the screen.
Right, that's just part of how Teams works, so yeah.
Paul, would you like to do the attendance roll call, please, and any apologies?
Yes, no problem, Chair. As we have in previous meetings, it's just very straightforward. I'll do a roll call of the members of the committee. If you can just confirm your attendance, unmute your microphone, confirm your attendance, and then pop yourself back on mute again. So first of all, Councillor Allen.
Here.
Thank you, Councillor. Councillor Clark.
Here.
Thank you. Councillor Cousins.
Present, Mr. Dalton.
Thank you. Councillor Heslop.
Here.
Thank you, Councillor. Councillor Cindy Hughes.
Here.
Thank you, Councillor. Councillor Charles Johnson.
Here.
Thank you, Councillor. Councillor Mrs. Doris Jones.
Yes, here.
Thank you. Councillor Keir.
I'm here, thank you, Paul.
Thank you, Councillor. Councillor Lee.
Present.
Thank you. And Councillor Lister.
Present.
Thank you. Councillor Marshall.
I'm here, Paul. Cheers.
Thank you, Councillor. Councillor McCollum.
Here, Mr. Dalton.
Thank you, Councillor. Councillor Tate.
Afternoon, Paul.
Hi, Councillor. Thank you. Councillor Tostervan.
Here.
Thank you, Councillor. And Councillor Wallace.
Present.
Thank you, Councillor. That's a full complement, Chair. I'll pass back over to you. Thank you.
Thank you. So no apologies. Are there any declarations of interest?
Chair, if I might interject, apologies. Just a correction. There is Emma Richardson, who's in the meeting, representation from the architects for this scheme.
Right. Thank you very much.
Emma Richardson. Thank you.
Okay. Thank you. Are there any declarations on any item on the agenda today from members? No? Getting some funny noises. Right, okay, we shall carry on. Can we approve the minutes of the last committee meeting held on the 28th of October? Can I have an approval on that, please? Anybody approve? Move them.
Can I move them, Chair?
I'll
Have I
second
got a
them.
seconded?
Chair. Yep.
Thank you very much. Thank you very much. I should now ask Mr. Andrew Errington, who is the Assistant Director of Law and Governance, to introduce procedures to the meeting, please. Mr. Errington.
Thank you, Chair. For each item, we'll begin with the Planning Officer presenting their report to members. And in doing so, they will draw members' attention to any further representations which have been received from supporters or objectors subsequent to those referred to in the report. The ward councillor, if any in attendance, may then address the meeting. Members may then ask questions of the applicant and/or agents if they wish. It's an opportunity for members to seek clarification on facts. It's not an opportunity for the applicant or agent to make a presentation. The planning officer will then summarise the key planning issues. Members then can question officers, and the planning officer will be invited to make any final comments. Members will then debate the application and formulate motion or motions on which to vote and will take vote or votes. Thank you, Chair.
Thank you, Mr. Errington. That takes us straight into planning applications on item 5. And if we start with the Hall, Dinsdale Park, Middleton St George, it's actually Neasham, not Middleton St George. And can I take you over to Mr. Coates, please, to address that matter? Mr. Coates.
Thank you very much, Chair. Hello, members. I hope everybody can hear me okay. The first item on the agenda on page 19 relates to the formation of a hard standing landscaping to Unit 4 and 5, including the erection of stone walls, and that's at the Hall, Dinsdale Park, in St George, which is located at the end of that particular arrow to the southwest of Middleton St George. The hall itself and the buildings around it are Grade 2 listed. What I would stress in this particular application, we're not actually revisiting the extant planning permission that is in place for the hall for the conversion of the units. That is there, and the developers will be relying on that. This is the treatment of the external part of the property, which I'll go into in a little bit more detail as we move along. The next slide, please, Mike. That's the picture of the site, the map of the site. Dinsdale Hall is the large building to the southern part of the slide. What we're talking about is the two offshoots, if you like, which is Units 4 and 5, which are the subject of a separate planning permission within that red line boundary. So what we're dealing with today is the parking area, which is to the west, indicated by the parking tab, and also the internal treatment of the external space, the garden area, for both of these particular units. It's actually proposed to create some defensible space within that area by constructing a wall to make sure both of those properties have some internal amenity space which is private to them. The car parking area to the western side is going to be sensitively treated following consultations with the applicant and our conservation officer. Next slide, please, Mike. That's an aerial shot. You can see the general context of the area. This site, which was granted planning permission in general terms back in 2000, didn't get off to a particularly good start. There were a number of land ownership and leaseholder issues which prevented the site moving forward very quickly in a particularly satisfactory way. The current leaseholder or current owners of the site have moved forward quite significantly. And I was very surprised when I visited the site a few weeks ago how far this had come on. And it has actually developed into a very positive scheme and a reworking of a listed structure which has been particularly successful. You'll see the 8 objections highlighted by red triangles dotted around the site. Next slide, please, Mike. Beg your pardon, could I just go back 2 slides, members? Apologies. 2 slides, Mike, if I may. That one. The area we're actually talking about, the wall I'm about to show you, is on the bottom left corner. If we can perhaps indicate that, Mike, if you would. On the slide, that's it. So when we refer to the wall, it's actually in that area there. Thank you. We'll go back to the wall slide, Mike, if we could. Thank you. So at the moment, there's a rather inappropriate timber wall and concrete post wall, which has been constructed there historically. It didn't have planning permission. It certainly detracted from the main front of the listed structure. So as part of this car parking arrangement, to improve the linkages between the hall itself and the buildings to the rear, this wall is intended to be constructed with a wrought iron gate, and it's very similar, indeed identical, to most of the walls that run around Dinsdale Park. So in officers' view, it represents a significant improvement to what's there at the moment. Next slide, please, Mike. That's the plan view. The hashed area, or the dotted area to the left-hand side, that's the car parking area that's proposed. It's currently an area set aside for no particular purpose. It's not a particularly attractive feature in relation to the in relation to the listed building. This seeks to improve things significantly. At the front part of the site, there would be 2 car parking spaces in series, nose to tail. At the back end of the site, closest to the hall, that's still intended to be green space, an open space, which adds to the setting of the listed building itself. In the middle part of the site, if you can just point to that, Mike, where the wall is there. Oh, thank you. There's a wall constructed through there, which subdivides that amenity space and has some direct defensible space, which would be directly related to the 2 properties that you see on the plan. What I would stress is that we're actually not talking about the principle of the conversion of the houses. The developer will be relying on an extant planning permission. It's simply the subdivision of that amenity space in the central part of the site and the treatment of the car parking area to the left-hand side of the screen. You'll also notice, those with much better eyes than mine, that there is a treatment, a sensitive treatment to that car parking area. It's likely to be grasscrete. For members who aren't particularly familiar with that, it is a form of reinforcing surfacing material which grass actually grows through, and technically you can actually run a lawnmower across it, but it does have the appearance of a grassed area, although it has much more strength to enable a car park or a car to be parked on it. Thank you, Mike. Next slide, Mike, please. That's the general pictures of the area. The car parking area which we were looking at in plan view a moment ago is the one on the bottom right hand of the screen, the photograph on the bottom right hand of the screen. You can see it is just a general green area, and you'll see a particular inappropriate timber and concrete fence at the back of the site. That is the fence that will be removed, and that's where the concrete or the brick wall will be constructed in appropriate materials to match the rest of the site. So that is seen to be a significant improvement to the setting of the listed buildings. On the bottom left-hand side, that is a view across from the main door of the hall, and that's looking the other side of that fence, which is shown on the right-hand side of the screen. That will be removed. That wall will be put in. An appropriate gate will be put in, which will represent a significant improvement. The green area you can see in the bottom left-hand side would, of course, be retained as open landscaping. Thanks, Chair. The other points I would like to briefly mention, if I can. Neasham Parish Council have no objections to the scheme. There have been 8 objections from those around the site, set out on page 21. It's not in keeping with previous consents in somebody's opinion. Impact on visual amenity. All parking should be accommodated in the grounds of Dinsdale Hall rather than on this particular site. It adversely affects the visual appearance of the historic courtyard. Currently no pedestrian access to units 4 and 5 due to unauthorised erection of a timber fence, and that's what I was making reference to a few moments ago. That will physically be removed. The wall I showed you earlier on will be replacing it, and there will be a pedestrian access within it. As the property is a listed building, we've consulted our conservation officer, and his points or comments are particularly important in areas such as this. He's concluded that the proposal would have less than substantial harm on the listed buildings, and this is a concept that we've discussed before, Chair. In that, what does less than substantial harm actually mean? It is a spectrum of harm to a listed building. So less than substantial harm can be right at the bottom end of the spectrum, where there's essentially no harm at all, or at the top end of the spectrum, it can be less than substantial harm, but nevertheless have a significant impact on the listed building, which can justify a refusal of planning permission. In this particular case, the conservation officer has come to the conclusion that less than substantial harm is the bottom end of that spectrum. So he is quite happy that what is proposed here would not have a detrimental effect on the listed building. I would add to that, Chair, that in light of the improvements that they're likely to come about here, particularly by the removal of the timber walls and the posts and replacement with appropriate brickwork, I think that would have a positive effect on the listed building, and it has led to the positive recommendation. As I've been speaking, Chair, it occurred to me I have missed a slide which demonstrates that internal courtyard that we were talking about, which is the next one, I think, Mike, if you wouldn't mind moving on. That's the area inside the buildings to be converted and improved, and that's the area that the applicant is seeking to construct the wall to create defensible space for 2 private areas associated with the proposed development, which of course already has planning permission. So again, the construction of that Flemish bond wall to create those 2 spaces, in my opinion, it's fairly straightforward. It creates a massive improvement to what's there at the moment, particularly with a setting with a listed building. The recommendation, Chair, is to grant planning permission. On page 25, you'll see 2 particular conditions, which is condition 3 and condition 4. Condition 3 relates to hours of operation, because it is all pretty tight around there. There are lots of residential properties, and it is reasonable we impose that condition, which limits the hours of construction. As far as the listed building status is concerned, you'll see condition 4 talks about mortar mix and brick samples and brick types, indeed paving stones. That is the request of the conservation officer. You'll also see in condition 4, point D, relates to method of damp proofing. It is a strange thing, you may ask, that we would consider during a planning application. That's more concerned under the building regulations. But in this particular case, there is a slight change in level which will occur as a result of the car parking going in. It's just to ensure that, that the listed building attached to that car parking area or adjacent to that car parking area wouldn't be damaged in any particular way. So it's just requiring details of that dam proofing in those circumstances. Excuse me. We have some additional letters, Chair, which I'd just like to bring your attention to, in addition to the ones that we've already reviewed and mentioned within the report. That they aren't new letters or new additions. They are from people who have already made representations. There is the occupier of To The Hall, Dinsdale Park. There has been, as I indicated earlier on in the presentation, a long-standing dispute, problems with various owners of the hall, and particularly with leaseholders and how they've been arranged. Of course, that isn't something that we can be really considering as part of the planning process, and undoubtedly is a civil matter which may regard or need some attention. But as far as we're concerned, to make a decision through the planning process, we need to set those things aside. And there has been another 3 letters, in addition, 4 letters, beg your pardon, supporting this essentially civil matters which are associated with the main letter that's arrived. I want to bring those to your attention because we received them. It's right and proper you should know about them. But in terms of material weight attached to the decision-making process, I would ask you to set those aside because they are essentially relating to civil matters. So the recommendation, Chair, is to grant planning permission subject to the 4 conditions set out on the bottom of page 24 and 25. Thank you, Chair.
Thank you, Mr. Coates. Ward Councillor Treskavin, are you planning on saying anything on this as the Ward Councillor?
Yes, I could say something.
Can I ask you to come in now?
Thank you, Chair. I have visited the site and I've discussed the application with the residents. Obviously, they understand that these buildings are going to be developed, but they have raised a number of concerns. Obviously, Mr. Coates has covered a number of those, but I still would like to ask further questions in relation to a number of the items, and I will do as part of the process. But these concerns do relate to the parking. They do relate to the road and the courtyard, and again, in terms of historic agreements, which they believe should be taken into consideration as part of this application. So I would like a little bit further information on those. And I'll ask the questions in the most appropriate place. Thank you, Chair.
Thank you, Councillor. I would like to invite committee members now, if you would like to ask any technical or factual questions, please, either from the applicant, the agent. Any members wishing to speak? No members, no, thank you. Oh, sorry, your hand's still up, Councillor Treskavin. Are you wishing to ask questions?
I think this is possibly a question for the agent, and it relates to the courtyard and the fact of the fire escape door at the back of the hall, which actually enters from the hall into the courtyard. Now, prior to the development of these buildings, people would have been able to leave that courtyard in terms of access if there was a fire. But as it stands at the moment, the access is now blocked because the only access that can be achieved is via and across another resident's land. And there is no agreement in place for that access to occur. So could they explain how people would get away from the fire in the case of this development?
Thank you, Councillor Treskavin. I think we have, is it Emma Richardson present to represent the applicant? Ms. Richardson, would you like to answer Councillor Treskavin's question, please?
So this is about the fire escape, which currently goes out into the external courtyard. John, did you hear what the question was?
Yes, I did. Yeah.
Sorry, can you hear this?
Yeah.
Can members hear this? Okay. Yeah. Yes, I think we can, Ms. Richardson.
Yes.
Yeah. That as far as we're concerned, that the fire.
Not here. Sorry, we can't hear. So the fire escape goes out of the building at the back and then it goes through the courtyard. As far as we're concerned, and on behalf of the client who owns the leasehold, they do have rights through that, and they're currently, like Dave alluded to, this is a civil matter. They're currently getting something back legally to say what rights they have of access through the courtyard. But as far as they're aware, they have full rights through that courtyard, and they're just putting things in place at the minute to make sure that's they've got the formalities of that in place to show everybody.
Chescafan.
That isn't the impression I got from the residents yesterday. There's been no negotiation whatsoever. The resident of number 2, the hall, owns that land that would be the escape route from the courtyard, and no agreements are currently in place, and that is why there is concern being raised. Now, whether that is a civil matter or whether outside of this application, I'm not sure, but it is a very pertinent point in the fact that we're discussing the courtyard as such.
Like I said, they don't have that at present. They don't have the piece of paper to show the legalities of their access through there, but we will get that to you as soon as we've got that confirmed.
Okay, so we will need to see that agreement then as part of the application, or is that outside of the application? I don't understand that. Perhaps Mr. Coates can update us.
Yes.
Through you, Chair, if I may, perhaps I can assist Councillor Thompson. The area we're talking about, if Mike would be kind enough to point that out, if you can go to a point that's a bit further down, there, that's it. Currently, there's a fire escape from the main building that moves onto that area. The intention would be to come out of here and turn right. So through, have you got it, Mike? Yeah, turn right. That's it, and that's the area we're actually talking about, where the fire escape would exist. That then moves along that area to the right into the open land. One of the key things that I would urge members to think about here, that is an issue which, as I alluded to earlier, is a civil matter, and if that can't be ascertained, if it can't be established in terms of ownership, that does present some significant problems for the applicant, because they are required to provide a fire escape. What they aren't required to do, as far as the determination of the planning application, is to provide a fire escape. That would be done through the fire officer or indeed the building regulations. So I wouldn't advise members to look at this as a stumbling block, should they wish to grant planning permission for it. It would be covered by a separate part of the legislation. Thank you.
Councillor Chescafan, that's your question. Do you have any more to say on that?
Only that, as Mr. Coates pointed out, the escape route is to the right-hand side and out onto that piece of land on the right-hand side of the drawing. Now, that is the ownership that isn't in the possession of the people who are developing these units, and that there lies the problem, because there isn't a route to access onto the road out at the front, because they can't cross that land at the moment.
Mr. Coates, are you comfortable with this? Because should we look further into this before we?
Through you, Chair, I do fully appreciate Councillor Tosvin's point and the importance of providing fire escapes, but it's not our role here. I would strongly suggest to establish that. It doesn't stop us, should members be minded to grant planning permission. And it's quite clear that the building regulations, and there are other mechanisms to ensure that takes place. And clearly, if they can't meet the requirements of other legislation by providing that access or egress from the building for fire purposes, they can't build the site out, and that does have to be settled. But I don't believe, my advice to you, it doesn't have to be settled here and now, and it certainly wouldn't justify the refusal of planning permission, because on challenge, somebody would say, well, that is something that is covered by a different part of the legislation. You shouldn't be granting or refusing planning permission on that basis.
Okay, Councillor Marshall.
Thanks, Chair. Could I just have it clarified? That is one of the objections that I circled in paragraph 10 on page 21 about this emergency access. If this is a health and safety issue, can we reasonably give planning consent when there's a clear health and safety issue, or can we just give consent subject to that health and safety matter being resolved? Thanks, Chair.
Thanks, Councillor Marshall. Through you, Chair. No, I don't think it is appropriate to refuse planning permission or even put a condition on an approval which says another piece of legislation has to be complied with, because that's just a matter of fact that has to occur, whatever members decide to do with this application. So I think it would be inappropriate to put a condition on to say that the building regulations have to be complied with, or the fire officer has to be complied with, because it's simply not a matter that we need to consider, particularly if that was challenged in some shape, to an appeal or whatever. I wouldn't be able to sit in front of an inspector and say, well, we put that condition on for this purpose, because his response to that would be, well, what on earth for? Because other people deal with that. That's not up for you to consider. So the short answer to your question, Councillor Marshall, is that can we put a condition on? My advice would be no. There's nothing wrong to put an informative on a decision notice, which would set out other requirements that somebody might wish to consider before the start, and certainly bringing somebody's attention to the need to ensure that fire escape is secured.
Can I just ask, which is the obvious to me, would those people who are responsible for the fire authority not be present at this meeting, or not have an input into the application, or is that not the way it does?
Through you, Chair, no, not necessarily. The fire regulations are quite a separate piece of legislation, which, to be direct, I don't think we need to bother ourselves with to make a decision today. Other than, I mean, the point I made to Councillor Marshall is that if it's felt that important, and quite clearly this is important, that members wish to put an informative on any approval to ensure that the applicants are fully aware of the responsibilities to follow other pieces of legislation, that would be a perfectly acceptable way of moving forward, in my view.
Councillor Tuskerton.
Thank you, Chair. I do have another couple of the questions, but I'm not sure whether they're for the agent or Mr. Coates. They relate to the parking and access to the parking spaces, etc., and the unadopted road. Should I ask them now, or should I ask them later?
I would just like.
What is the direct? Can I bring Councillor Kerr in first, and then we'll come back to that one.
I'd just like some clarification on where the dispute lies, in as much as the owner of the ground, I think, is not allowing, or saying is that permission is not granted. The leaseholder thinks that it is granted, and the leaseholder is the person doing the development, and they seem to be two different people. So I find it strange that those two haven't came to an agreement, and I know that's nothing to do with this part here, but obviously there's something wrong there when these two folks haven't agreed something. The leaseholder, I take it, leases that ground from the landowner, and there must be something difficult there for the landowner not to allow his leaseholder to grant egress through that through that area. I just find it confusing, and I'm just wondering if you could clarify that for us.
Can I make a comment on
Yes,
that?
please.
If it's a technical, yes, you can. If it's a technical question, which it is from Councillor Kerr. So, yes, OK, Ms Richardson, I'll let you come in and answer to Councillor Kerr and Councillor Tuscoven.
I've just had confirmation from the owner that they definitely own half of the courtway, and they've got full rights to go over the other half of the land. They own the freehold of the whole site.
Chair, if I may come back,
yes.
That's a useful piece of information. As it is the uncertainty around the objectors' issues as well. But going back to the point I made, it is a civil matter which needs to be sorted out one way or the other. But it's not something that we can sort out for anybody at this stage. It lies out of our considerations.
It was just to make sure that if things weren't resolved, then essentially they wouldn't comply because of fire regulations, and essentially the thing would fall anyway. That's the only that's the only reason I'm trying to clarify it, David.
OK. No further answers showing, and we have spoke to Mrs Richardson. Councillor Cousins, was your hand up there? No? No, OK. Mr Coates, would you like to summarise on all of this, please, before we take it further?
Councillor Tate had his hand up.
Oh, sorry, Councillor Tate, I didn't see you there. Sorry, my apologies.
It's okay, no problem. It's just, thank you, Chair. We asked for questions for the developer, but my question's for Dave specifically, I think. The erection of the wooden fence that's apparently unauthorised is going to be replaced, which I think, with a wall which is better suited. Why is it that the wall has a gate in and the current fence doesn't? I'm looking at one of the objections which says currently no pedestrian access. So is there supposed to be access to there, or?
Through you, Chair, to Councillor Tate, there is a proposal to have access for most of the car parking actually is in front or to the side of the hall. So there is a proposal for one of the units to be able to access that area so they can park their car in a different part of the site. The point I was making in terms of it's much improved, and I agree with you, Councillor Tate, that the unauthorised timber and post fence is appalling. And
yeah, it doesn't suit the building.
If this wasn't going to be regularised by this permission, should members grant it, we would be looking at taking some direct action on that, Councillor Tate, to have it removed anyway.
Okay, so just to go back 1 second, in regards to the fence currently that blocks all access, the new wall will have a gate. Is anybody against the gate looking at that objection? No?
Not as far as I'm aware, Councillor Tate, no. And we certainly don't have an objection to a gate being within there from a planning perspective.
Thank you.
Are there any further questions before I get Mr Coates to summarise the application? No, Mr Coates?
Thank you, Chair. I do have some further questions.
Councillor Tostin.
Sorry, I couldn't get my...
All right, sorry.
Partly it relates to the gate because the gate is actually being put in for a purpose so that the residents who are going to occupy the new Unit 5 will have to park their car out right up next to the hall. Now, A, where is the designated parking space for number 5? And B, do you really believe that a person is going to park their car opposite the hall and then walk round to where they are actually going to live? And the reason I ask that is because there's obviously a lot of concerns being raised about the road and the fact that Unit 4 is going to potentially have a parking space next to their property, or 2 parking spaces next to their property, and yet there's a lot of controversy about the fact that there was supposed to be no further traffic coming down that road from the eastern side of the hall unless there was action taken in relation to that road and the upkeep of that road. Now that then relates to an old covenant, which I know Mr. Coates has already said doesn't apply, but the residents are quite clear that there is a need for that covenant to apply, and that the council should be involved in making sure via a section 33 agreement that this work is actually takes place if access is given to further cars and traffic to come down that road. Now, it's all very complex, and the residents have gone into it in an extreme lot of detail, and I don't know that it can just be dismissed as not being actually relevant to the application when they are very, very clear from the research they've done that it does apply, and this agreement is in perpetuity. And therefore, if we're granting parking spaces, we are granting access. And if we're granting access, then this covenant should come into place, which would therefore give them some help in determining the fact that the road would be upkept, which at the moment it isn't. It's in a disgraceful condition. It is an adopted road, so it isn't rightly the council's responsibility, but they are, by virtue of this agreement, as far as I can see and the residents can see, linked into actually helping the residents to achieve some sort of update with this road if additional traffic is going to be allowed to come down it, if that all makes sense. And that's my understanding of what is being said. Could you give us some feedback on that, either in terms of the council, Mr. Coates, or from the applicant?
I mean, perhaps, but if I can go first, Chair, if I may. The road isn't in particularly good order. I don't think that actually moving 2 cars up and down it would make any significant difference in that respect. But the point you made, Councillor Tosvin, is a valid one, in that it is a private road. That the council have no responsibility. I mean, there's lots of private roads and lanes that aren't adopted, which the council have simply no responsibility for, and it is very much a civil matter. And if residents felt that strongly about the state of the road, they would have to do something about it themselves. There's nothing that the council would be able to do to go down there and tarmac it or cobble it or anything like that. That would be very much down to them. And it's something quite detached and separate from the planning consideration, in my opinion.
Thank you, Mr. Coates. Mr. Richardson, I think the question was also directed at yourself. See that? Ms. Richardson, are you with us still or not?
I am, yes.
I think this question from Councillor Toscafin was also directed at you. Would you like to respond, please? Just on the technical and factual matters, a direct response to Councillor Toscafin, please.
Yes. 1 second. We do already have access along that road as part of the freehold, and the roadworks only ever covered the main access to the gate. So we can go down that road as part of the planning at the minute. We can go down that the planning that's extant. We could go down that road anyway. It would be 2 extra cars that went down there to the parking spaces. And it would also alleviate, if we don't put the parking spaces at that point, there is an area over the road which doesn't belong to anyone, which I presume the people who moved into these houses would use instead of the parking spaces we try to put for them for their properties.
Thank you. I understand, Andy Errington. Mr. Errington, I think you've shown your hand up. Do you want to come in on any of this, please? Mr. Errington.
Yes, Chair. I haven't, in respect to this application, I haven't been asked any questions by Mr. Coates regarding objections that have come in concerning the Section 33 agreement, which the residents are referring to. While the debate's been ongoing, I've quickly looked at the planning portal and had a look at one of the letters where there is reference to the Section 33 agreement that Councillor Tostevens also mentioned. Just to say that I do recall about 3 years ago there been a complaint put in regarding the council not taking action under that Section 33 agreement. When one of the residents said that we were able to and that we should be taking action. My advice at that time, I didn't deal with the final response to the complaint, but my advice at that time was that there may be a liability. There was no liability under planning, because as Mr. Coates said, that time's passed. But under the Section 33 agreement, it potentially was possible for the council to become involved. Now, I don't know, as I said, it's 3 years ago, and I wasn't involved in the final response, so I don't know what the response to that complaint was. But just to say that it has been looked into previously, and potentially we could have taken action under Section 33, but I don't know if we did or we didn't, or we decided that we weren't going to, or what the decision was. But just to say that we are aware that there is a Section 33 agreement.
Thank you, Mr. Errington. Councillor Tostevens, do you want to come back in?
I would like to, please, yes. I accept that the applicant thinks it's only 2 extra cars, but if the agreement says no additional traffic, then 2 extra cars are 2 extra cars, and therefore the implications of Section 33 come into play. And therefore, I think that needs to be explored a little bit more, particularly in what Andrew Errington has just told us. The other aspect that the applicant has said is that if those cars don't get some extra parking space, then they will park in the area which is just beyond that. Well, that particular, because it doesn't belong to anybody in particular, well, that actually belongs for parking for the riverside and the Mew and the courtyard. It's not designated parking for the development as such, so therefore they can't park there in theory. The point I want to raise also about the parking is that these 2 parking spaces outside for unit number 4 are now going to be directly in front of the window or alongside the window of another property, which is number 1, the Mews. And again, Mr. Coates says this isn't of concern, but quite frankly, this property has enjoyed nobody parking next to it for quite a number of years, and suddenly they're going to have 2 cars right outside their front window, and nobody seems to be giving any consideration to that. Also, it's quite apparent that if that road is in a poor state, and it's a very busy road, and it is quite narrow, and these units number 4 and 5, to the front of them there is a little bit of verge, and obviously it's natural for people to want to park right outside their front door, and that is going to start to block the road to some degree, and cause a problem for the residents further down and the residents directly opposite them. So there needs to be some form of legislation which would actually stop them parking right in front of their own doors if that was acceptable. So there are a number of problems. That's what I'm saying, and I think it needs further consideration giving to this Section 33 before any decision is made.
Yeah.
Through your chair, if I may, just in part response to Councillor Tostevens, the piece of land as it stands at the moment, I would argue presents us with an opportunity to improve the situation quite markedly. It's a piece of land which is overgrown. When I was last there, it wasn't a particularly attractive piece of land, which it did have a detrimental effect on the setting of the listed building. So that said, that this is an opportunity in my mind to actually tidy that piece of land up, to improve the setting of the listed building, and to ensure that car parking wasn't done haphazardly on the front of the development. As a fallback position, it would be possible. It's not desirable, but it would be possible for whoever occupied number 4, I think it is, just park the car there anyway, and without bothering with us. And I wouldn't want that to happen, because I think that would be throwing the baby out with the bathwater, because I think there's a dual process here. One, we can seek to solve the car parking issue, and 2, we can adequately improve that setting of the listed building by dealing with that piece of land in a sensitive way. So the last thing I'd want to do is get hung up on the state of the road, which I appreciate may well be a problem for folks, but it still wouldn't stop anybody driving down it and parking on that particular area in an unimproved state. And this is a dual process of getting car parking provision in place, and also making significant improvements to the setting of a listed building.
Councillor Allen, you had your hand up for some time. Can I bring you in now?
Thank you, Chair. It's just a point of clarification, really. Mr. Coates has had to reiterate several times that a lot of this, these comments that are being made and the objections that are being raised do not fall within our remit as a planning applications committee. Could he just clarify for me why, in fact, has this particular application come before this committee when so much of it doesn't actually fall within our jurisdiction? Thank you.
Mr. Coates.
Directly back to you, Councillor Allen. The reason it's come back before is because it does require listed building consent because of its impact in adjacent to the listed building structures, and it also does require planning permission because of the engineering operation, the grasscrete, the formalisation of the wall, the grassed area. It does change things quite significantly enough to represent an engineering operation as for requiring planning permission. If they did nothing at all, they wouldn't have to bother with us. It wouldn't require planning permission and it wouldn't require listed building consent. They could haphazardly park a car on that piece of ground, create all sorts of mud, mess, but it wouldn't in itself require planning permission. The reason it's come before us is to because it is an engineering operation of type, and it does require listed building consent and planning permission, and it solves two problems in my view. It gets two cars off the road, and it improves the setting of the listed building. Councillor, that would be my response to that.
Thank you.
Councillor Johnson, can I bring you in next, please?
No, thank you, Chair. I'm always concerned about any application which subsequently has an effect on the existing residents, and to hear that the car parking will in fact crowd into the front of the existing dwellings in the front or the front room or which particular room it is, I don't think that's an acceptable position. And I think we need to concentrate a little bit more on the effects of the existing residents. Thank you, Chair.
Thank you. Councillor Toscovin.
I appreciate what Mr. Coates is saying in relation to improving the outlook in terms of that piece of land. and I feel that the residents are understanding of that as well. The difficulty is that if this section 33 that has an implications on that road is valid, the fact that 2 more cars are being given permission to come down there by virtue of the fact that they're allowed to park there officially. I know anybody can come up and down there, but if you're giving official parking spaces, this is 2 extra cars, which means that additional traffic is now coming down that road, which the agreement says shouldn't happen unless, by virtue of this section 33, there is some consideration given to the upkeep of that an adopted road by the leaseholder. So this would be the applicant. So the applicant needs to take some responsibility for that road in terms of its upkeep and improvements by virtue of the fact that they want to actually increase the traffic down that road. And I think that's what the residents are actually saying is the main concern.
Councillor Hughes. Councillor Hughes.
Yes, thank you, Chair. I'm really seeking guidance in relation to whether these considerations, obviously residents have expressed their view through the objections that they've made, but are they actually planning considerations that we as a committee need to take account of when we take our decision? Obviously, in relation to the highways officer, the highways engineer raised no objections. And clearly, the increase by 2 vehicles along a road, it is impactful, but is it significant in relation to this particular application? I would guess not, because he hasn't raised any objection. So my concern is that, you know, clearly residents would like to park in front of their house. In my ward, everybody would like to do that, but that's an impossibility. So I'm just wondering if we could be guided again, either by Andrew Arrington or Mr. Coates, in relation to the issues that are our business as a planning committee. Thank you, Chair.
Thank you. Councillor Truscovern, your hand's still up again. Are you wanting to come back?
I just wanted to make it clear that, yes, the only issue, I think, is this section 33, which the residents are absolutely intent on insisting is relevant to the application. And I don't think Mr. Arrington at this stage has given us sufficient information to say whether it is or it isn't. And I don't feel that the fact that it was dealt with 3 years ago and that we can't recall the answer is sufficient explanation at this stage. Thank you.
Councillor Clark.
Yeah, I just, all I've heard from Dave is that everything else that's been discussed is not relevant. We have a clear direction within our parameters of where we should go with this, which is to accept with officers' recommendations. All the other stuff, yes, it's it's not relevant to this committee. So I don't know where we're going with this, and I tend to agree with Councillor Hughes, but I think I've just probably answered that on behalf of Dave, that we have had that clear guidance from the outset. So what follows this follows it. It's, in my opinion.
Thank you, Councillor Clark. Councillor Hughes, you've got your hand up again.
Yeah, thank you, Chair. With all due respect, I asked a question, I posed a question, and I got a further response from Councillor Tustovan. So if I could please have clarification from Mr. Coates and Mr. Arrington in relation to the point I raised and the point that Councillor Clark raised, please.
Thank you. I was going to bring them in when members had their opportunity to answer. So before I bring Mr. Arrington in, I see I've still got Councillor Marshall and Councillor Tate. Councillor Tate, I think you were next. Is he still offline?
Hello.
Hello, Councillor Tate.
Oh, hello, thank you. Yeah, sorry, I'm having some connection issues, which I'm hopefully resolved. Just in regards to the bit I missed before, are we to take into account the section 33 or not as part of our decision? Because I wasn't convinced that either heard the answer to it, or is it something we would take into account whilst making a decision? Because the answer Andrew gave me didn't resolve it either.
Thank you, Councillor Tate. We're going to bring Andrew in after Councillor Marshall spoke. Then you've all had your opportunity to ask questions, and Councillor Errington will sum them all up, and Mr. Coates. Councillor, I've made you councillor, and you're a solicitor. You don't want to be a councillor, Mr. Errington, do you? You're in next.
Thanks, Chair. I agree with Councillor Hughes that I'd like a little bit more explanation as well. And with that explanation, as somebody who is totally ignorant of what a Section 33 is and the impact it could have, could you give us some, briefly obviously, of what a Section 33 is and why it's impactful or could be impactful in this case? Thanks, Chair.
Okay. Mr. Errington, would you like to sum up all those questions you've been asked, please, on Section 33?
Thank you, Chair. It's an agreement that was made under Section 33 of the Local Government Miscellaneous Provisions Act 1982. It's a general provision that allows councils to impose covenants on land, even though it has no retained land that gets the benefit of those covenants. In this case, Section 33 is still in force. And as I say, it potentially is possible that the council could enforce the provisions of that Section 33 agreement. Because I haven't been asked prior to the meeting about this, and as I say, it's 3 years since I dealt with it, I'm not entirely sure what was in the Section 33 agreement. My feeling would be that in terms of making a decision on the application today, that they are two separate matters. The planning decision can be made. A decision can be made in planning terms that they can use this road or park or things of that nature. If it turns out through the Section 33 agreement that this can't happen, then that would be separate. That would be a separate matter. That often happens with our planning applications, not necessarily with Section 33 agreements, but with other matters. That the planning they can get planning permission, but then it turns out they can't implement that planning application for other reasons, as Mr. Coates mentioned with the emergency access. That would come under building regulations. So if they can't implement the planning permission for other reasons, then so be it. But we can certainly look at the Section 33 after this meeting and look at what the decision was 3 years ago as to what involvement the council wants to have or can have, and deal with that as a separate matter.
You come back to me. Oh, sorry.
Thanks, Andrew. That's fine.
Councillor Tuscan, do you want to go back to Mr. Errington?
I do, yes. So if we approve this application, which allowed the passage of these two additional cars, and by virtue of the fact that the covenant in Section 33, the implications were by the fact that we've approved this extra traffic to come down that road, we have in fact approved the fact that the applicant and in conjunction with the council need to maintain that road. Would that be acceptable to everyone? So in fact, what we're approving is the fact that we don't know the implications of the Section 33 in terms of this additional two cars coming down there, which from all the covenants suggest shouldn't happen on a permanent basis. So if we now approve that on a permanent basis and it's found that the Section 33 is in fact relevant to this application, then we would be insisting that the applicant then maintain that road to a suitable standard. Is that correct?
Without knowing what's in the section, without knowing what's in the Section 33 agreement, I can't comment as to whether what you've been told is in the Section 33 agreement is the actual case.
So I don't think we got a clear answer on that, to my mind, and therefore to my mind, the two are interrelated. That's all I'm saying. Thank you.
Thank you, Councillor Toscovin. Councillor Tate, you've had your hand up some time. Are you switched in now?
Yes, thank you, Chair.
Thank you.
Just on the back of what Andrew's given us, if you were aware of what the Section 33 included and it didn't support this application, would the application have come to the committee?
Mr. Errington? Thinking all of that.
I'm not quite sure. I'm not quite sure what you were meaning by that. Sorry, I've not quite got the gist of the question.
So the members are being told at the moment we're not sure what's included within this in the Section 33 and Covenant because we haven't looked at it prior to the meeting. If it didn't support this application and the two additional vehicles, like Councillor Tostovin's saying, would you have brought it to the committee for us to look at?
Are you meaning would it have been refused by?
Yes, that's what I mean.
Planning without coming here. No, because it's Mr. Coates can answer that, but
Yeah,
my guess would be that he would still have brought it because it's a separate issue. But
through you, Chair. Sorry to interrupt. If I may just. Yes, the question, the answer to the question, Councillor Tate, is would it change my recommendation to you today? Emphatically, no, absolutely not. It wouldn't be something I would be suggesting if it came. It wouldn't be a reason for refusal for 2 car parking spaces, nor would it be a reason to refuse an extension to an existing house in that area, which may up the car parking capacity and movement in that area. And I think it's very similar in that respect. So whatever action or non-action the council decides to take under sections 33, my strong advice to members is that there's no reason to stop you from proceeding in whatever decision you make today. I think they're two totally unrelated issues. Thanks, Councillor.
Councillor Hughes, I see your hands up.
Thank you, Chair. I'm sorry to belabor the point, but I think the question is that if we take a decision today, will it advantage or disadvantage either of the parties in any future negotiation in relation to this covenant, this section 23, in the sense that if we take a decision, and I know this is slightly outside of what we should even be considering, but I think that what my colleagues and I are concerned about is that if we were to take a planning decision today, would it advantage or disadvantage either party in the future negotiations? So when you actually look at what that section 23 entails and how they'll have to deal with the situation, will it advantage or disadvantage them? Thank you.
Again, through you, Chair. In all sorts of circumstances, when we make planning decisions, some people are advantaged, some people are disadvantaged. It's just the way of the world, I suppose. But what I'm keen to stress to members is that the state of the road, the state of the road isn't a material planning consideration here. It's not something we should be confusing ourselves with when we actually deliberate one way or the other, whether we should grant or refuse planning permission. It certainly wouldn't be a position, for example, if we were to refuse, or members were to refuse planning permission, that couldn't be a reason for refusal. So that kind of focuses my mind on it's not really a material consideration. If it was a material consideration, members could use that legitimately to refuse planning permission. And my strong advice to you would be, please don't do that, because it wouldn't stand on its own 2 feet.
Thank you, Councillor Johnson. Councillor Johnson, you're on mute. Thank you.
Thank you.
Okay.
I did raise the question about parking in front of existing residents, and I didn't really get a reply on that. So what, can you just clarify, Mr. Coates, the distances between the parked cars and the existing fronts of the current residents' houses?
Yeah, yes, Councillor, can. Mike, would you mind putting the plans up again, if you would, please, just so I can illustrate that to Councillor Johnson. That's the site there, Councillor. The two car parking spaces in series, one in front of the other, at the northern part of that site. If you can just point to that, Mike, if you would. There's one there, and one just in front of it. The property it's intended to serve is to the right when it's actually converted. The property that may have an issue with that is directly to the left-hand side, just off screen, which is about there.
Right. So what's that distance across there then?
It would be no more than about 2 metres, maximum 2 metres.
So it is going to be right in front of somebody's window.
Indeed, yes, yeah. But it as I say, it could be used as a parking area anyway. Somebody could choose to drive onto there without any of our control anyway. So that circumstance, that set of circumstances would exist without consent.
Yeah, but we're now encouraging somebody to park there. What I'm concerned about is that in dark nights, of course, there's going to be headlights and all sorts going on.
Right. As I say, in the presentation, or certainly in the report, it wasn't considered to be the parking of a car there would have such an adverse impact on somebody's residential amenity that it would justify a refusal. I mean, I suppose a comparison, Councillor Johnson, is that, you know, in a semi-detached house or even two detached houses which share drives, the relationships, share tandem drives, the relationships can be quite similar to the one we're actually looking at now.
Right, thanks, Mr. Coates. Thank you. Yeah.
Chair, you're muted.
Councillor Toscovin, Councillor Tay, I'm going to bring you both in just to say, ask you questions. Then I'm going to stop the debate and bring in the planning officer to summarise on all the questions that's being asked. Councillor Toscovin.
Point.
You're still muted, Councillor.
Councillor Toscovin, you're on mute. And then it's Councillor Kay after you.
Right. The fact that it's not the same as a tandem drive because there isn't a tandem with it. It's just one driveway with two cars and the residents adjacent to the property, to the car parking, is right next to it. The front window of their lounge or their bedroom, I'm not quite sure which, is right alongside the two parking spaces for two cars with two sets of lights going in and out. So it doesn't equate to the same as a tandem drive. The second point is, in terms of the debate about the Section 2033 and insufficient information, is it possible to link any sort of condition to the application in terms of that we need to investigate as part of the process, or is that not possible? Thank you.
Thank you, Councillor Toscovin. Councillor Kay, I think you've taken your hand down, so you're not asking a question. Can you answer Councillor Toscovin, Mr. Coates, and then I think we'll summarise after that. You can do 2 in 1 if you like. Okay.
Thanks, Councillor Toscovin. The short reply would be no. I mean, if members, in answering Councillor Hughes's question, Is it a justifiable reason to refuse this permission because of that section 33? Clearly not. I would urge members not to do that. If members felt on balance that there was an effect on residential amenity of the adjacent property, that is a legitimate course of action. But again, our advice to you, or my advice to you, is it wouldn't justify a reason for refusal in itself. There's lots of examples where cars are parked relatively close to adjacent properties, and I think it would be quite difficult to sustain on appeal. But going back to my original point I made some time ago, is that there are lots of benefits here, and there are some costs associated with that. But one of the principal benefits are, yes, there is an improvement to that area of unkempt land. There's an opportunity to introduce car parking off the main road, and probably more importantly, the balance is an opportunity to present this or improve the setting of the listed building. And there's an amalgam of all of those issues that we're asking you to consider. But one thing I would urge you not to consider, or consider and set aside, is the potential for any refusal based on the state of the road outside. That's something that could be dealt with, considered or not considered by the council at any future date. It's not a justification to refuse this permission, in my view.
Comments or?
Yes, thank you, Chair. I have nothing further to add. Thank you.
Okay. In that case, are there any further debates or anything further from members before we take it to a vote? Councillor Clark.
Yeah, I'd just like to propose that we accept the proposal based on officers' recommendations.
Seconded.
Moved and seconded. Can I forward it to you, Mr. Dalton, please, now to deal with the, are there any further amendments to the motion that's been moved? No? Sorry, Councillor Tate. Where's he gone?
Apologies, no, I haven't got anything to add.
Okay. Any further amendments? Mr. Dalton, can you take it to the vote then, please?
Certainly, Chair. So the motion on the table before you is the officer to grant planning permission subject to the 4 conditions outlined on page 24 and 25 of the submitted report. And as we have done previously, I will call members' names out. If they can indicate whether they are voting for, against or abstaining, I will mark accordingly, and then I will report back the vote. So Councillor Allen.
For.
Thank you. Councillor Clark.
For.
Councillor Cousins.
For.
Councillor Heslop.
Abstain.
Councillor Cindy Hughes.
For.
Councillor Charles Johnson.
Abstain.
Thank you, Councillor. Councillor Mrs. Doris Jones. Sorry, Councillor Jones, you're on mute.
For.
For, thank you. Councillor Keir.
For.
Councillor Lee. Sorry, Councillor Lee. For, thank you. Councillor Lister.
For.
Councillor Marshall.
For.
Councillor McCollum.
For.
Thank you, Councillor. Councillor Tate.
Abstain.
Councillor Tostervan.
I think there are too many unanswered questions, so abstain.
Councillor Wallace.
For.
Thank you. If you bear with me a moment, please. Okay, Chair, that's 11 votes for the motion, none against and 4 abstentions. Therefore, the motion's carried. Thank you.
Thank you. The motion has been accepted. Thank you all very much. Can we now move on to the next item, which is the same address, Dinsdale Park. Yep.
I'm sorry, Mr. Coates, you're on mute.
You're on mute.
Thank you. Thank you. There's apologies, Chair. I don't want to sort of repeat everything I've just said. I think we've had a very comprehensive debate. This is clearly the listed building element associated with the Planning Commission. They are identical in that respect. They're just their applications made under different parts of legislation. The key issue I think I wanted to mention is that it does present purely in listed building terms an opportunity to improve substantially the setting of the existing listed building. It's something that has the support of our conservation officer, subject to some minor details which are covered in the conditions on the bottom of page 32 and 33. So the recommendation, Chair, is to grant listed building consent subject to those conditions on 32 and 33. Thank you very much.
Thank you, Mr. Coates. Councillor Toscaven, as the ward councillor, do you want to comment on this issue? You're on mute, Councillor Toscaven.
Thank you, Chair. Just on the conditions, frankly, the fact that in previous occasions repairs associated around the site have been done not as sympathetically as would have been liked, and therefore could we actually suggest in the conditions that the keeping is the repairs, the updates are done in keeping with the existing building in terms of, because it just says details of paving stones, it doesn't say as per existing building, etc., etc. So could the conditions be altered to reflect that? Thank you.
Mr. Coates.
Thanks, Councillor Toscaven. Thanks, Chair. Just to sort of reaffirm, it's not the building in condition number 3. I'm not sure how much further we could control that, Councillor, and unless you're perhaps a bit more specific on what you were seeking to achieve.
I think it was just in terms of the fact that there is a certain type of stone that has been used on the remainder of the building, and the residents were asking if that similar stone could be used on creation of the new walls, etc., etc., because currently any repairs that are done around the hall and other residences have been done at a lower standard, and they didn't want to see that in terms of this new development. Thank you.
No, thanks for the clarification, Councillor. No, I think I do appreciate the point you're making, and it's a discussion that I had with the planning officer on site with the applicant's agent. It is quite clear that some of the external repair works have been less than satisfactory, but I do think this presents a huge potential to improve that massively. I think condition number 3 covers the paving stones, the gates, the method of damp proofing, the brickwork. So there is a clear methodology within that condition which delivers a high degree of control, in my view.
Okay, thank you.
Councillor Keir.
Thank you, Chair. I'd like to propose the motion as put forward by the council.
I'll second that.
It's a bit soon for that yet. Can we finish taking questions and then come back with that, Councillor Keir? Councillor Allen?
Thank you, Chair. Mr. Coates, can I just make sure that I've got this right in my own mind? When you put these conditions on, it means that the applicants have to come back with specific details of what you have listed. And if you aren't happy with what they have listed, you can tell them to go back and rethink. And that just because they have sent you something doesn't mean that you will accept it willy-nilly. Thank you.
Through you, Chair. Thanks, Councillor Allen. That's absolutely spot on. That's correct. That there is a requirement. Not all conditions is a requirement before commencement, but certainly the one condition 3, which goes to the heart of what we're considering here in terms of quality and materials, that is a requirement to have that submission prior to commencement on site. So to be absolutely clear, they have to come back to us before they do anything, and 2, they have to have our approval in terms of quality before they commence.
Thank you. Well, there's no further hands shown. I assume that nobody wants to ask the agent or any further questions of the officer. And it has been moved and seconded to accept the officer's recommendation. Are members happy that we go ahead and do that now? No further questions or debate? Paul, can I hand that to you then, please?
Thank you, Chair. Yes, no problem. So the motion before members was moved by Councillor Keir, seconded by Councillor Clark, to grant listed building consent subject to the 3 conditions outlined on page 32 and 33 of the submitted report. And again, I'll just go through members of the committee, and if you can indicate which way you're voting accordingly. Councillor Allen, please.
4.
Thank you. Councillor Clark.
4.
Councillor Cousins.
4.
Councillor Heslop.
4.
Councillor Cindy Hughes.
4.
Councillor Charles Johnson.
Abstain.
Councillor Mrs Doris Jones.
4.
Councillor Keir.
4.
Councillor Lee.
4.
Councillor Lister.
4.
Councillor Marshall.
4.
Councillor McCollum.
4.
Councillor Tate.
Abstain.
Councillor Tostervan.
Abstain.
And Councillor Wallace.
4.
Thank you. If you bear with me a moment, please. Okay, Chair, so that's 12 votes for the motion and 3 votes against. The motion is carried. Thank you.
Thank you all very much. That's been passed. Can we now move on to item 2 on your agendas, please? Item 6, which is part 2. Can I ask that we move part 2 on block? Everybody in agreement? Yes? Anybody disagree? No. There are no supplementary items. Does anybody have any part 1 questions, please? No. Thank you all very much indeed. That now moves us to part 3, where we will exclude the public pursuant to section 100B, paragraph 5 of the Local Governments Act 1972. The